because of the recent case situation with the Department of Education, we've received as board members several requests and questions about what's happening. And so we feel it's prudent at this juncture to talk a little bit about the FEA lawsuit and the judge's order. And then we hopefully will have time after that discussion to have the mental health workshop presentation and workshop. So bear with us, and I'm going to actually turn it over to Mr. Porter, who's going to give us an update, and then some board member, if you'd like to ask questions, we can have some discussion around the information. So thank you.
Thank you, Madam Chair and board members. As you all know, yesterday the court in Leon County made a ruling on a lawsuit filed by the FEA against the Department of Education and the governor regarding the Commissioner of Education's order that demanded the reopening of schools. The order basically struck out all the provisions in the emergency order that dealt with having a plan in place in order to open schools. That's a very positive thing for local governments, and especially Hillsborough. The judge recognized that the decision about opening schools and running of schools belongs solely and squarely within the realm of local school boards, not in Tallahassee. So that's a big win in the idea of local government control. So that's a very positive ruling. That came out yesterday, and you all became aware of it. I sent the order to you, and you've read about it in the news. Right before the close of business, the Commissioner of Education filed an appeal of that order to the First District Court of Appeals. And so what happens when an appeal is filed, the order that was issued yesterday is automatically stayed. What that means in layman's terms is it's on hold. So the order was issued, an appeal was filed, and everything is still back to where it was before the order was issued. And so, again, it's a very positive ruling for local governments, but as far as any action that could be taken, we're in a holding pattern right now until the lawsuit plays itself out. The order has been appealed to the First District Court of Appeals, and then it could ultimately be appealed to the Florida Supreme Court. They have 15 days in order to respond to the appeal and get their briefs in. So, in other words, there's nothing the board can really do right now. I want to be very clear about setting expectations. The board is not in a position to vote on anything today regarding this, either today at the workshop or tonight's board meeting. A vote would not be proper. And the most conservative thing to do would be to continue to follow the lawsuit and see where it leads. But at this point, that's just an update to let you all know where it is. The order came out, it was automatically appealed, and it's automatically on hold until the First District Court of Appeals can hear it.
Thank you, Mr. Porter. And so I think the question on most people's minds right now is, and either you or the superintendent may want to address this, is the plan moving forward going to stay the same as it is now? Is it e-learning this week, and then we open brick and mortar beginning next week, or e-learning for those who chose that? So is the plan changing, or will the plan stay the same? Would you like to address that, Mr. Superintendent?
Yes, ma'am. Through the chair, as Mr. Porter just spoke about, right now that the current motion due to the appeal, it's on pause. So right now, my recommendation would be to continue to plan as previously approved originally, so that we continue to stay within the funding model outlined by the Florida Department of Education. And at the same time, we want to make certain that we have a number of teachers, a number of parents that they want just consistent knowledge of what their next steps will be, and we're prepared, and we've been working diligently to prepare to create the model of choice for our community. So, with knowing that if the appeal is approved and it removes any of the recent injunction, then that means if we continue to pause, then we would be out of close to $200 million, and I don't recommend that at this time, because that's all linked. As you know through the chair, our budget's all linked to personnel, and around 80+% is all personnel, and I don't want to get to a point where we don't have sufficient funding to better protect all of our employees within our organization.
Okay, thank you, Mr. Superintendent. So, so nothing is going to change as far as the current plan. So e-learning this week, and then brick and mortar next week, and then we watch with Mr. Porter the continuing proceedings and appeal process.
And we'll continue to update you as events unfold.
Okay. And then board members, I don't see anyone in the queue. Does anyone have questions, comments that they'd like to share or discuss? At this juncture, then we will go ahead and move into the mental health workshop. I know this will come up in the board meeting later today, so we can have further discussion if it warrants later today at our board meeting.
Yeah, Madam Chair, if you would indulge me, I think it's appropriate to talk about it at the board meeting. I think there was a suggestion made that it be heard this morning because it is really fast-moving. There's a great public interest in it, and I think it's appropriate to talk about it at the board meeting as well. And that things could change between now and the board meeting, but we don't anticipate that happening. But I'll provide a similar update at the board meeting this afternoon.
Okay, thank you very much. All right,